tradition in opening certain events and functions. We welcome you to Mi'kmaq territory and appreciate you coming tonight to discuss these things that I'm looking forward to hearing more about as well. Being Indigenous is a very important distinction to me that people know that it is unceded territory. This is kind of something that is base one for unpacking a lot of other things. So it's really, sometimes it becomes more of a practice to do these things, but I think it really is important to acknowledge the territory that we're on and to think about what that means as far as it being unceded, and then of course the other side of it and what you see when you go out this door. What does that reflect? Does it reflect that we are on unceded territory? It doesn't to me. I live every day in this city feeling like I live a colonized life. So this is part of where we need to start to build and develop the relationships we need, to have the information we need, the education we need, to start doing the work that has to be done for people who walk through this city daily and don't feel like they're represented here on their own territory. Thank you for coming. And thank you for organizing and being here to present.
Thanks, Killa, for that welcome. Again, welcome everybody. My name is Robin. I work at the Council of Canadians here in Halifax. The Council of Canadians is a national social justice organization. We do a whole lot of work from water to climate change to trade justice and healthcare. We do all sorts of things. And one of the main projects I've been working on lately has to do more with Indigenous rights here in Mi'kmaq, which is the Alton Gas project. So we might talk about that a little bit. I also, as a settler on this land, want to acknowledge that this is unceded Mi'kmaq territory, not just as a passing reference, but as a reminder to myself and other settlers that there is a troubled past and ongoing trauma of colonization here and across Canada. And I'm excited that you've all joined us tonight to learn about one potentially very powerful tool of reconciliation, which is the UN Declaration on the Rights of Indigenous People, which we'll probably be calling UNDRIP from now on, so please get used to that acronym. This declaration is rather unique in the UN, as I understand, because it was created with the rights holders at the table, which is pretty unusual. Usually the declarations are just made by the UN and not having actual people impacted by them at the table. So this, perhaps our panelists will talk more about the creation of UNDRIP. It's important to recognize that it does not create, this declaration doesn't create new rights for Indigenous peoples. It just cements the rights that were already there and that we should have been paying attention to the whole time. This year actually marks 10 years since the declaration was created at the UN level. So it's a bit frustrating that 10 years later Canada hasn't done a whole lot with that declaration. But I'm happy that our panel tonight will tell us more about what that implementation might look like and how it's sort of playing out right now. So before I introduce our excellent panelists, I'll let you know that tonight's talk is being live streamed. So we've got one camera over here and a microphone. When it comes time to have a Q&A, I'm going to be taking questions off my computer as well. So if you're watching the live cast, hey, I think there's like 6 or 7 people right now watching so far. Hey guys. When it comes time for Q&A, I'll take questions via Facebook. So if you're on the live stream, you can just type your question right onto the event page, and I'll see it. And for all of you, yeah, I'm going to have everyone write their questions on paper and pass them forward. That way I can kind of compile and see if there's common questions that are coming up. So we can do it that way. And then I can say them very loudly so that the live stream folks can hear. So without further ado, first up will be Naomi Metallic. Thank you for joining us. Naomi spent 10 years practicing law, focusing on Indigenous issues, and recently joined the Schulich School of Law at Dalhousie. as she says, to work for First Nations in a different way through teaching, writing, and speaking about how the law can be a tool for reconciliation and improving the lives of Indigenous peoples. And then after that, we'll have Patti DOYLE-BEDWELL, also at Dalhousie University. Patti is a Mi'kmaq woman, lawyer, and writer. She's published numerous papers on Aboriginal women, employment equity, education and leadership, and now teaches Native studies from a Mi'kmaq perspective at Dalhousie. So please help me in welcoming our speakers.
Wen in Dalhousie Naomi Metallic, Akdalewit Listiguch, Akbiji Chibuktuk, Oldasi Begisim Giskok. Just saying, my name is Naomi. I'm originally from the Listiguch Mi'kmaq First Nation. And I live here in Halifax now, and I'm also very happy to be here. I'm going to go first because Patti told me to. And hopefully not too much overlap, or we'll see. In going forward. So the question that was put to me by the organizers is, given UNDRIP, what would consent look like with respect to projects involving resource extraction and other issues? And so a lot of this in Canada, we already have this sort of doctrine that's existed since, well, before 2003, but there was a Supreme Court of Canada case in 2003 called HIDA, which talked about the duty to consult. So I'm going to talk a little bit about UNDRIP and where we might be going with UNDRIP, and then I'm going to sort of talk about where I think we're going by comparing it to some of my own experience with the duty to consult. So without further ado, so I guess I'll start with UNDRIP, and I feel Patti will probably have far more things to add to what I have to say on this. But it is in terms of the background and these sorts of things. But one of the first things I guess I will say about it is that one of the sort of frequent points that are perhaps made by people who are not who are reluctant to see it implemented in Canada is that, well, it's a declaration, it's not a convention, it's not been ratified. And I've actually made arguments based on UNDRIP in the courts in a couple of cases that I've been involved with. And the first thing I say, well, is a declaration doesn't have to be endorsed or ratified. In fact, the way that a declaration is sort of brought into effect is simply it simply is just endorsed. It doesn't have to be signed by a country or even having those sort of strictures. As Robin mentioned, this is not UNDRIP is not new rights. In fact, it is based on many of the rights in it are actually sort of specific articulations with respect to Indigenous people. However, they're based on several other conventions that Canada has in fact ratified. And that's a really important thing to note, that it isn't new. And so, in fact, I would say that probably the cornerstone of UNDRIP is the right to self-determination. And the right to self-determination was recognized in the International Covenant on Economic and Social and Cultural Rights that Canada ratified, I believe, sometime in the 70s. So none of this is new, although I guess the wonderful thing about UNDRIP is that it is sort of reframing rights that already exist through a particular Indigenous lens, which I think is important. But we can't sort of denigrate it or downplay it simply because it's a declaration. Because it is related in so many ways to covenants. And I'm not a full expert on international human rights documents, but the more that I learn, I'm learning that it's a rich web of, it's not just one document, it's many documents. And when you talk to people who work with them, they'll cite this convention, this one, and they all kind of inform each other. So it's a rich tapestry. And one thing I've learned is that my legal education has poorly prepared me to really work with these documents, and I think law schools and law professions need to do more to help lawyers and judges learn this. In fact, one of the things that I did is I'm in touch with people who work on judicial education for judges, and I definitely think that they need quite a bit of education on how UNDRIP relates to all these other instruments and how it should be applied in Canada. So it's so in some respects, when people say that UNDRIP, well, it's not hard law. It's not been ratified in Canada. Again, you don't need to. It just needs to be endorsed by Canada. But it doesn't have necessarily the same legal force that even an international covenant would. But that's not to say it doesn't have any meaning or impact. In fact, there's this doctrine in Canadian law that says, it's called the doctrine of the presumption of conformity. And essentially it holds that we should not interpret our domestic law, our charter, Section 35 of the Constitution Act, or even human rights legislation, any domestic law, in a way that they would violate international human rights documents. That essentially human rights should be the sort of floor, and that we shouldn't interpret our domestic obligations inconsistent with our international obligations. There have been some cases to date that have actually recognized that with respect to UNDRIP. So UNDRIP's been used to interpret the Canadian Human Rights Act. I argued it in a case involving administrative law principles. So already there is some work that has been done with UNDRIP. But again, there's one issue that an expert that I work with sometimes has raised is that sometimes lawyers just raise it, but they don't know how to argue it in case law. And that has led to a few cases where judges say, I'm not even going to bother applying it because I don't know how to apply it and you haven't given me the tools to do it. So lots of education still needed on this front. So another point that I will raise, I guess, is that I mentioned earlier that self-determination is the cornerstone of the UN Declaration on the Rights of Indigenous People, and that in itself is enshrined in other covenants. And a free, prior, and informed consent, which is when we're talking about duty to consult or the issues that arise in duty to consult, that's often where the focus is on this idea of free, prior, and informed consent. And people make the link between self-determination and free, prior, and informed consent. One is an offshoot from the other, because self-determination recognizes a people's ability to be able to make decisions that impact them. And to have a choice. And of course, that's what free, prior, and informed consent is. It's the ability to make choices with respect to projects on Indigenous territory and affecting Indigenous interest. Another point I wanted to make about UNDRIP is that sometimes people are against UNDRIP because they say they kind of fear that it gives these absolute rights. And I think that's an important point to make, that UNDRIP actually doesn't give absolute rights. And that's when people say, well, we can't have full consent because that just doesn't balance. And that was an argument that the Harper government made with respect to UNDRIP, and that they were concerned about FPIC and it giving absolute rights. But there's actually a limitation provision in Section 46 of the UNDRIP, and that's not in Canadian law. In our law on Aboriginal rights, we do have limitations that the court has sort of read in that applies, and because they say no rights are absolute and there has to be a balancing. The interesting thing, though, is that the limitation provision in UNDRIP, and Patti, you might have some more views on that, but it does seem to actually require, I think, more, it's narrower or more limited than our current sort of rules in Canada around limitations and what limitations on rights should be. The Section 46 actually talks about that rights must be or limitations have to be strictly necessary solely for the purpose of securing due recognition and respect for the rights and freedoms of others, or for meeting the just and most compelling requirements of a democratic society. So I think if we're moving towards embracing UNDRIP and FPIC, then we're going to have to deal with how our current rules around how we limit rights actually interacts with Section 46 of UNDRIP. So sort of moving on, I'll leave sort of the technicalities of UNDRIP there. I will say that now we know that Canada has finally, at first the Harper government didn't want to endorse and didn't endorse the UN Declaration. It eventually did in 2010, but in a fairly limited way by saying, well, we have problems with FPIC, we have problems with self-determination. Now, under the Trudeau government, Canada has now endorsed the document without reservation. And it is, the government has said it's going to implement the Truth and Reconciliation Commission report, and the sort of cornerstone of that report is implementation of the UN Declaration, which this government has said it will be doing. Now, there were there's been discussions to this point by the Minister of Justice and the Minister of Indigenous Affairs about where they're going to be taking this. And the government hasn't said too much yet. One thing that Jody Wilson-Raybould said in a speech last summer was that she didn't feel that the UN Declaration should be just imported sort of whole hog into law, but rather the way that the government wanted to approach it was by ensuring that UNDRIP was reflected in all of its legislation and sort of doing it on a more sort of piece-by-piece basis, looking at both policy and legislation. Some people in the media actually interpreted that as meaning that they didn't want to implement UNDRIP at all. That was a misunderstanding, a mischaracterization. But, you know, I do think that there are, and I've heard very good arguments about why there needs to be some legislation that recognizes the principles of UNDRIP and also sets out how the government is going to, the process that the government's going to take in making sure that it's meeting UNDRIP. So one thing the government has also said is that it wants to implement UNDRIP through Section 35, which for some people raises some concerns, because when you compare what's in the UN Declaration to what has been recognized under Canadian law to date in terms of Aboriginal and treaty rights, Canada's been far more limited in terms of what the expanse of what's in UNDRIP. And so that's a bit of a concern. But I have also, on the other hand, heard the Minister of Justice say that, that UNDRIP now gives us a full box of rights. Because it used to be that we don't know what's in Section 35, it was an empty box. That's kind of how some scholars have expressed it. And the Minister of Justice has now said UNDRIP now gives us a full box of rights when it comes to Section 35. So that remains to be seen. Canada has announced in the last couple of weeks that it's now taking a review of all its policies and legislation in order to determine whether they're consistent with UNDRIP. So that's an interesting process as well, and I guess it remains to be seen where Canada's going with it. There hasn't been a ton of action yet. I think there's a lot of wait and see, but hopefully there's some positive movement happening sooner than later. One thing, a last point on UNDRIP that I want to make is, you know, I said already that UNDRIP isn't new. But, you know, even going back to what's in international conventions, as I said, that it's not new because we already have rights that have been recognized. But if you go even back further than that, I mean, what TRC is getting at and what UNDRIP is really getting at is recognition of self-determination and land rights. And, you know, sometimes that's get expressed as a nation-to-nation relationship. And I mean, that's essentially what many indigenous treaties were all about, right? Was establishing this relationship of nation to nation where you have mutual respect and equitable sharing of land and resources. And that's what many indigenous people thought their treaty relationship was supposed to establish. So in many ways, this is not very new at all, but some of this has been established in principles and law 200 years ago. They just haven't been recognized very well. Right. And I think in that sort of paradigm, you would want consent to be the standard of, you know, decisions on projects that affect both Indigenous and non-Indigenous people, because it's more of a partnership. All right, so how much time, how am I doing on time there?
Keep going.
Okay, all right. So I'm going to switch gears and talk a little bit about what would free, prior, and informed consent look like if we were to actually embrace UNDRIP. And I have to say, I'm not 100% sure what exactly it would look like, but I think it would look a lot different from what exists right now under Canadian law. So I'm going to talk about what I see as some of the problems of duty to consult as it currently exists, and what I think the free, prior, and informed consent could address. I guess the first major difference is that free, prior, and informed consent is a right to a result. Consent. Pretty clear, pretty easy. Duty to consult is only a right to a process of consultation. Okay? So I think those actually make really big differences in terms of how we approach stuff. So, you know, so the court has been really clear that it is only a process in terms of the duty to consult. The court has said repeatedly there's no duty to agree and there's no veto by Aboriginal people. Now, there's been a few cases where the court has said with respect to proven Aboriginal title that there may be consent owed up to the level, or duty, or consultation owed up to the level of consent. But the court's been really unclear about when that would be. And even when they said that, they said it wouldn't be in all cases. So I don't know, and more than anyone else, about when that would actually apply. Very unclear in Canadian law about when consent would apply based on just the current test for duty to consult. So because it's a process, the court then developed this spectrum, it calls it. It's kind of like a sliding scale to determine what level of protest what level of process an Indigenous group might be entitled to. And they said you decide that by looking at the strength of the claim that is being asserted and the degree of impact on the right. And by combining those two things, there's a spectrum, and you could be at the low end, or you could be at the high end, or you could be in the middle, right? The problem with that sort of design, I guess I would say, that I think, is that often the parties disagree very vehemently on where they fall on the spectrum. The government tends to always assess it at the low level, and First Nations generally assess it to be at the higher level. And courts are generally, and even the way the test is framed, the courts are pretty deferential to the government's view of things. And so we're sort of starting off where we're probably going to be in some sort of dispute on where we fall on that process spectrum. So there's lots of room for disagreement and lots of fighting as a result. And one of the things that has really come with the whole duty to consult doctrine since 2003 is a ton of litigation. That's almost all of it. I mean, there's other litigation going on, but that is a huge amount of litigation that has happened. So, but with consent, you don't really have all that room for error, right? Either you consent or you don't. You don't have this sort of process where you can kind of fall within this huge range of what's owing and lots of people potentially disagreeing on it. Okay, so when you only have process and no agreement, the other issue with that is I find that kind of, it depends. I'm not going to suggest that all governments who engage in consultation do so in bad faith, but it is a situation, and we lawyers have said that, oh, what an easy obligation on government. All they just have to do is just meet. They can start off thinking, I'm not going to change the project one way or another, but I'll have all the meetings, I'll go through the steps, right? So it's kind of like form over substance, or it can be, just so long as, you know, the appropriate number of meetings are had, or this type of thing. A court will not tend to really delve into it, or there's a greater tendency that a court will say, well, they had all these meetings, that's fine. So it is a process that you know, potentially can, for the cynics, say, well, it really doesn't actually lead to any real meaningful discussion. And so, you know, all you have to do is sort of document the process. And now, these days, that is sort of an industry that has actually created as a result of duty to consult. There are companies, if you are a proponent, you can hire a company, and the company will take care of your duty to consult with you. They will meet with the Indigenous groups. They will document every time that they met with the Indigenous group. They will keep every email, and all of it to sort of create a paper trail in case they ever get to court to be able to say, see, we met with the Indigenous. Well, I was in a case, and you know, they actually counted every single encounter. Like even an email to say, like, the meeting will be on next Wednesday at 2 p.m. That was counted, and they'd say, well, we had 75 interactions with the Indians, you know, and that's supposed to be sufficient. When if it's about getting it meaningfully actually hearing each other, or partnership, that's really not necessarily getting us there. It just, the whole sort of, the emphasis on process really almost kind of makes us a sort of a checkbox, you know, oh, check, we met with the Indians, done. You know, and so it's not really a relationship of real partnership. Yeah, and I guess the other thing that I would raise about process is that the way that it's sort of framed right now, it's almost led to this sort of compartmentalization. So the courts always want to look, where are we in the process? And so what is the decision made at this? It's not the broader, holistic, what is the project and are the Indigenous people in favor of it or not? But when you go to court on duty to consult cases, inevitably these days, it's all about essentially, where are we? And so there's been cases where a First Nation has brought a claim at the outset and the court said, you're too early. You have to see the process through and and then we'll decide whether so there's been a ton of cases where First Nations have gone to court and said, you're too early. There's now some cases starting to come out that say, oh, you're too late, you should have come early. And so we've got all these cases and we don't actually know when the right time is. Apparently there's never a right time to raise this. And so, and I think that because of all of the emphasis on process that this leads to this. Thank you. Okay, I'm almost done, so that's great. The other thing I think we need to be focused on a result as opposed to process, and I think UNDRIP will get us there. Another point I want to make about UNDRIP is that, or free, prior, and informed consent, is the informed part. And there's a real issue with the informed part in Canadian law as it stands right now. Whenever these types of projects, you will have just, books and books and reams of scientific, technical data about what are the impacts of the project and these sorts of things. And they are in the consultation process, essentially they can be just dropped on the Indigenous group and say, there you go, there's the information. Hope you understand the project now. Sometimes there are presentations that can be made by the proponent, but again, that's coming from the proponent, who may have a particular view about all the impacts on their project, that they're all rosy and fine or they can be met. There's real issues about the capacity of Indigenous groups to be able to really address these in a way that they're actually meaningfully understanding what the project is about. And there's a name for this. People call it death by 1,000 cuts. Essentially that just Indigenous people are just having numerous consultation requests kind of given to them. And then they don't really have the capacity to really be able to understand or address them. And currently under our law, although there's a few cases that have said, oh, maybe there is potentially an obligation on the government as part of its duty to fund, most cases have said no on this point of funding the consultation process, or at least assisting the First Nation in developing capacity. And so, there's a real concern that, that Indigenous people are, although even when the government is, meeting its duty, the information that the Indigenous people are getting are not really allowing them to make real informed, meaningful decisions about it. Yeah, so, my last point, I guess I have like 30 seconds. I just generally find that the position under Canadian law around the duty to consult is pretty unequal. We're not equal partners in this. There's a real inequality in position. The Crown essentially under the test gets to decide, the government gets to decide the level of consultation and what the process is. The First Nations can have input on it, but generally it's the government that gets to call the shots, and the courts, when they look at it, they generally defer to what the government decided for a process. And in addition to that, there's no way to say no in this process. So even if a group legitimately does not want to see it, they cannot. And they also cannot not participate. When Indigenous people don't participate in a consultation, the courts will and if they then try to challenge it in the courts will say, sorry, you didn't participate. There's an obligation for you to participate. You don't participate, you don't get to complain about anything. And because there's no veto, as the court says, there is no way to not say no. So we're sort of bound in a process that we can't say no to, that the government designs largely, and we even can't conscientiously object to it because they'll say, well, you had to participate. So I think there's a lot to be desired in terms of the current process, and I think consent and informed consent can be very helpful in moving to a better place. So thank you. Thank you.
And these issues were not being discussed, and UNDRIP was not in existence at that time. And the process of coming to an agreement the Declaration was almost 25 to 30 years, where many of my people, all the Indigenous peoples of the world, met in Geneva and tried to hammer this out. And the UN process is very complicated. And it has to go, it went from Geneva, and it ended up finally, when they finally got a draft, going to New York. One of the things that came out of all of this negotiation about our rights was the permanent forum on Indigenous peoples. So there are ways to bring forward our concerns, whether it's to the permanent forum, whether it's to the UN Human Rights Commission, where Aboriginal women went in the 70s and 80s to bring forward their complaints under UN human rights about their lack of ability to keep their status under the Indian Act. So it's been used in many different ways, but the process of getting to that point, I went to a conference, not a conference, I went to a class actually in Ireland on Indigenous human rights. And what I learned there was that there's Indigenous people all around the world, in every country. And when the draft declaration got to New York, there were 3 countries that did not ratify it at that level 10 years ago, and it was the United States, Canada, and Australia. What a surprise. I think that the UN declaration has a very different perspective than what was happening in Canadian law. And I'm just going to say, from my perspective, as a Mi'kmaq woman, I believe strongly that we are a sovereign nation. I believe strongly that the constitutional rights that we have don't limit us, that we should be able to hook into UNDRIP and get through issues like self-determination and free, prior, and informed consent, because this is our territory. So when we look at Alton Gas, for instance, I say very strongly that we have a right to say no to that project. Now, under Canadian law, I understand the duty to consult is about this sliding scale of consultation, and there's this idea that maybe we can't say no. And in Haida, I remember in that case, they were talking about the fact that, oh, well, the Indians were sitting on the committees, but it has to be more than that. And I think the fear, and I'm just going to say it's a fear, there's a narrative about Canada. And the narrative is that there was this empty land, the settlers came, they provided civilization, Aboriginal peoples, Indigenous peoples, we were the problem, even though we helped the settlers when they first got here. The Mi'kmaq people entered into treaties, peace and friendship treaties with the Crown through a spiritual process. And then what happened? Those treaties were ignored once we were no longer able to be military allies. Once the settlers came in and took our land. Once the Royal Proclamation of 1763 was no longer honored, which meant that the Crown had to actually negotiate with First Nations people for their territory, not just hand it to settlers. I just taught this today in my class. Settlers all came and took over our territory. So there's this narrative, like I said, that First Nations people have been somehow conquered by the settlers, that our territory is only limited to the reserves in Nova Scotia, which there are 13. We always say that we're on the unceded territory of the Mi'kmaq people. This is Mi'kmaqi, and this is Chibuktuk here. And we say that, but we have to actually put it in practice. So what does that mean if we're going to put it in practice? And the other thing that I see tied into UNDRIP is reconciliation. The Truth and Reconciliation Commission has said that we have to move forward to heal the hurts from the past. And one of the hurts from the past, and that's still being implemented, is this narrative that I talked about, that we were conquered, that we're only reserved, that we don't have any real rights except what the Canadian government has structured into the Constitution. And I know that in the past, and I recognize what Naomi said about Section 35(1) and 2 being an empty box. But what does it mean to have Aboriginal and treaty rights? And I argue that our rights include that of self-determination. And with Aboriginal title, which I'm not really a fan of either, I'll just say that right off the bat, because it's as my dear professors Mary Ellen Turpel and Trish Montori used to say, it's a legal fiction. It was something that's sui generis. It doesn't fit into what the English property law said about ownership. So we have some, as I say, it's a burden on Crown title. There's this, we have some interest in the land, but it's not considered ownership under the law. Not in the same way that we would think of ownership. And I always say, you know, it's about using the territory, and I was like, oh, do you have a cabin somewhere? Did somebody have a really nice cottage down in Mahone Bay? And someone would go, yeah, I do. It's like, oh, are you using it right now? No. Oh, well then, I can go get it. I can go use it myself. And people would say, no, you can't do that, it's mine. And that's the idea that somehow got lost, that this is ours. Our territory, we wanted to share. And as some of the elders have told me in my family, like Sawgate, they said that the treaties were set up as, I don't want to say a barrier, but like we wanted to share because that's part of our principles, but we didn't want to be taken over. So it's like, yes, you can use over here, and we're going to stay here, or we're going to share this space. But it was never about taking over. Never was it that way. So when I think of the Declaration, I'm always interested in implementing that in Canada, and it will cause a complete, I think, flip. Because we'd have to acknowledge, first of all, that the narrative that I just talked about is false. We'd have to acknowledge the impact of colonialism. We'd have to acknowledge the sovereignty of our peoples. Even in the United States, I hate to talk about the U.S. because I'm so Trumpicized. I have a real issue with Trump. Anyway, I think as most normal people do. One of the things that in the United States, there have been cases in the past in the U.S. Supreme Court where they talked about Aboriginal nations being domestic dependent nations, but there was a recognition of that nationhood. And I think with UNDRIP, we are going to have to go back to the idea that we have that sovereignty. And in Mi'kmaq world, we have a responsibility to take care of the earth, to take care of our territory. That's our responsibility. So I think that when we're moving into the Trump era, Standing Rock, for instance, Alton Gas is another example, the pipelines. And, you know, Naomi is right. They've put all these institutions, these corporations, they dump all this information on different bands or different groups, and what's going to happen, what environmental impact assessment has been done, and what's going to do to the fish or the salt or the whatever. And it's very difficult sometimes to incorporate all that information. So I think in terms of free prior and informed consent, we have to have the time to do what we need to do and recognize that our responsibility to the land and to the waters is something that has to be respected in that process. And we need to be able to take the time that we need. I am not an advocate of pipelines. I'm not an advocate of Alton Gas. I don't believe that that is the direction that we should be going. But that's a personal opinion, right? So that's my personal opinion. One of the things I wanted to also say is when I talk about reconciliation is that we have to see what's been done. And one of the things that's been done to our people is the Indian Act. I have to say right off the bat, I'm not a fan of the Indian Act. I wasn't an Indian under Canadian law until September 19th at 3:20 p.m. 1980. I wasn't a child grown up, though. I was grown up. Got married to a status Indian and got my status back. And it wasn't until 1985 that my mother got her status back under Bill C-31. So the Indian Act controls our lives from birth to beyond the grave. The Indian Act tells you how you manage your state and our reserves, all of those things. So one of the questions I always have about the Indian Act is how in God's name does a statute trump the Constitution? And then if we incorporate enter, there's no way, in my non-legal mind, that we could have the Indian Act alongside of enter. It just doesn't make any sense. They don't connect. There are some people who believe strongly that what the government is trying to do right now is turn us into municipalities. So the idea of self-determination would be, oh, you get to have your own little town and you can do whatever you want in your own little town, but you still have to answer to the province and to the feds. And I say, maybe I'm a fantasy person, okay, that's fine. My fantasy is that we actually, as Mi'kmaq people, operate as a nation. That we're not just 13 reserves in Nova Scotia, but we are a nation that covers our traditional territory, Nova Scotia, Newfoundland, PEI, New Brunswick, and Quebec. So when I see free, prior, and informed consent, I have this fantasy that we operate as a nation across those provincial boundaries, that we're not just part of. And I see ENDR as trying to lead to that, because self-determination is what we need to figure out how we're going to do that. There's no question that we have to figure out how to do that. And if we continue on the road that we're on, and we become municipalities, then we're not going to have that authority. Then you can bring in ENDR all you want, but it's not going to have the same impact as if our actual nation was recognized as a nation and that we were treated as one of the founding nations of Canada. Because right now we're not. We can talk about nation to nation, they used to come out and say it every week. But it's the action of how they do that makes a difference. So the last thing I want to say, I have all these great notes, and I wrote them down, and now I can't read them. about reconciliation. It's about changing the narrative. It's about looking at our laws in Canada and making sure that our national interests as Mi'kmaq people, our nation interests, are recognized and affirmed. That we have the right to say no. So we can't just, and this is what I'm saying, it's my fantasy, I've been saying this for years, but we can't just limit ourselves to a reserve. We have to recognize the sovereignty of our Mi'kmaq people and the right to make those decisions, because that's what self-determination is. And it's not what the government says it is. We have to sit down and look at maybe creating a new treaty of understanding that takes our responsibilities as Mi'kmaq people to protect the land, the water, the animals, our language, our culture, as seriously as we feel those responsibilities and have those recognized. And that's what I see as self-determination with UNDRIP. And I know that the government's trying to figure it out, but as long as we have the Indian Act in place, it's going to be very difficult. And as a Mi'kmaq woman, it feels like her blood sugar is taking it out. The last thing I want to say is that I think in terms of reconciliation, we need to understand what happened in the past. We need to understand, like when we have that Senator Baybuck or Bayback or whatever her name was, that said the residential schools weren't bad. We have to educate ourselves. And I think it's incumbent upon all of us, because I wasn't born with this knowledge. Well, kind of. No, I don't know. But being a Mi'kmaq woman means educating myself to my culture, my language, my responsibilities. My great uncle is the treaty keeper. I didn't learn that till I was 20-something years old. So in our family, that's part of our responsibility. So all of us as Mi'kmaq people and as the settlers need to come to an understanding of what those treaties mean. And if we need to create a new treaty of understanding, maybe that's what we should be working on, because we do have a responsibility to take care and to be respectful and to share. And be who we are as Mi'kmaq people, as a sovereign nation. That's what I believe, that's what I want to see happen. And I think UNDRIP would bring that, hopefully, closer to the fore, so we can change the narrative.
All right.
Thanks.
Thank you so much, both of you. That was wonderful. Good one, Ed. I want to open space for questions, and I also want to give myself a second to set up my computer again. So I'm going to hand out and have some help, hopefully, handing out some paper. So I'd love it if everyone took a second to either think to yourself or chat with your neighbor about questions that you had throughout the talk. I'll hand out some paper and pens, and you can write them down and pass them forward. And then I'll get my computer back up so I can get the folks in the live stream to type their questions in online. And then while you're all doing that, I have a big question for you too. So I'll do all those things. And then question time.
All right.
It's okay. result of free, prior, and informed consent. And Patti, you named the Indian Act and everyone being broken down into resident reserves instead of nations. So my big question, I guess, is if you could envision, I find it hard to envision, so maybe you can help us to envision what it would actually be like if, maybe for the example of the Alton Gas project, or maybe more abstractly, what would it really be like for a nation, as opposed to reserves, to be consulted with the intention of reaching consent? What would that actually be like? Because at least from my understanding, we don't have very many structures necessary for that. So what kinds of structures would be necessary? Who would decide when consent was reached? All that juicy stuff.
That's not a hard question.
That's the big one. No, that's the really big one. And maybe there isn't a full answer, but that's fine.
Can you repeat that question, please?
Okay, I'll try. If we're really trying to reach consent around, for example, projects like resource development projects, how do we actually reach that consent? Who gives the consent, and how do we actually get there? Because we're not really doing any of that at this point.
You want to go first?
Sure. I have a fantasy, and we have, as Mi'kmaq people, a traditional governance structure that still exists. Now, it may not be the best. I mean, some people may not like it because it's the Grand Council of the Mi'kmaq people. And unfortunately, we just lost one of our members the other day, Buddhist. It's like our law keeper. So we have this structure that operates, I don't know if it's on top of or underneath the Indian Chief and Council. So there are in every community, Mi'kmaq community, there are representatives that sit on the Grand Council. Now, the Grand Council Chief, which is Ben Soboy, is involved in these discussions, but they don't really have any legal authority. The only legal authority under the Indian Act is the Band Council of Chiefs. So what I like to see, and the closest this is to, the closest I see is like the Atlantic Policy Congress of First Nations Chiefs, where all the Indian Act chiefs come together and talk about issues. But they always deal with the individual, the government deals with the individual band. Like if it's Shuby or it's Millbrook or like so that's what I see is our nation coming together with our traditional governance process, having that recognized, and then having the Atlantic Policy Congress of First Nations Chiefs, which is basically technical advice to the chiefs, but have a process that's all of our provinces where we have our territory and bring those forward. Now, interestingly, that Senator Bayback said the other day that she wanted to undermine, that's what it is, but let's just not undermine. I have a low blood sugar, I don't know what I'm saying. No, she wants to have a process where instead of going to Chief and Council, she wants to go to the grassroots people. Because sometimes even Chief and Council make decisions that the grassroots people don't agree with. So one of the things that we have to do, I think, is start making sure that people have a say. And if we're not going to go for the full throttle Mi'kmaq Nation traditional governance, then at least we should have a process where people in the community can help make decisions on projects that make such a difference in our lives. And for instance, Member 2 made a decision to invest and be part of the Donkin mine, the coal mining, which I just went crazy. But how did they do that? Did they go to a referendum? Did they get consultation with the people in the community? And that's, I think, is the most important thing, is to have our people in the community be recognized and have a say. And if we have to go to a referendum, if we have to go to all our chiefs going forward in a more regional way, having our traditional governance involved, that's what it means. Also, I have a little bunch.
Sure. So in 1996, the Royal Commission on Aboriginal Peoples put out a multi-volume, extensive work that was informed by scholars and meetings with communities across the country. It's, you know, it's even more expansive. I mean, TRC was focused on the impacts of residential schools, but the Royal Commission report was actually focused on the whole relationship, and it's really it's a 20-year-old document. It really wasn't implemented hardly at all by government. There was changes in government, but this document spends a lot of time thinking about those precise issues. So it's not like these are things that nobody has ever thought about, no one's ever written about. And the sort of idea that Patti has is not sort of far off from what the Royal Commission report actually envisions in terms of moving towards self-determination and self-government for Indigenous people. So they say it cannot be based on band structures. First of all, they're too small to be impractical, right? What they say is they would prefer to see groups operating as nations, but recognizing that there may be some potentially, you know, from time to time issues with borders that have been drawn between our territories, but leaving that freedom to the Indigenous group. So they recognize a whole areas of jurisdiction where Indigenous people should be self-determining. Some they say are core, that meaning that really nobody would argue that Indigenous people shouldn't have the right to actually exercise decision-making power over. So decisions about services and programs in their community, about language and culture, about governance stuff, that should be left to Indigenous people. And what the RCAP said was that actually that just exists in law. That's a right that Indigenous people already have. But to make it more clear for everybody involved, it would be great if the government legislated law to actually recognize those jurisdictions on those core areas. And then the RCAP also recognized that there are a bunch of other areas of, let's say, overlapping jurisdiction between the federal government, the provinces, and Indigenous people. And it's about land use and these types of issues about how, you know, projects that would occur on the land and equal sharing or fair sharing of land and resources. And so what they say with that is that we have to have a treaty process. So reinvigorating our existing treaties, signing new treaties, but a real treaty. There has been a treaty process going on since about the 70s, but it is as slow as you can imagine. And it really doesn't move unless there's really the political will to move it. But what the RCAP envisioned was a whole process of negotiation of treaties on these areas outside of the core areas of jurisdiction, which would be like a partnership, and that this is where some of these harder issues would be discussed, but it would be on a consent basis. So, yeah, I think that's a feasible model for moving forward.
It's a great answer to a very tough question. I'm just going to grab some of these from the crowd. Yeah. Oh my.
I think you missed one thing in that answer was speaking and dealing with people in good faith.
Yeah.
That's the word.
I
That's
agree.
what lacks.
They're so good. They're not getting any smaller either, so it's only the beginning. Okay, I'm just trying to put these all together. I'm not seeing any coming in from online, so if anyone's got them, feel free. Okay. There's several about the Indian Act. Do you want to talk about the Indian Act some more?
Sure.
Okay, so people are curious about what would be involved in repealing the Indian Act. And what would be the major changes or differences for Indigenous people and the relationship with the government? Do you want me to repeat that?
No. I think, unless other people want to repeat it. The Indian Act is, Naomi might have a different perspective, because I see it as something that is just a colonial instrument of oppression. But at the same time, I can say that, but then at the same time I will say, well, we're talking about government responsibilities to Aboriginal people, which is the F word called fiduciary. I remember Bertha Wilson saying in the case way back in the day that, you know, the Indian Act would be a place to start looking at the responsibilities that the government has with education, land, health, things like that. So when in 1980s, when there was some movement to change Section 12(1)(b), which was the section that gave, took away status from Aboriginal women who married out of the community, and there was all kinds of other parts that took away rights under the Indian Act. There was a discussion, argument, that at the time, National Indian Brotherhood, which is now the Assembly of First Nations, fought very hard against changing one part of the Indian Act. Because I think the fear is that we would lose, because so much depends on it. So much, it's our reserves, it's who we are. Some people have called it internalized colonialism. Like I have a band number, so that means I'm a real Indian. So I think in trying to repeal it, I think that, like right now, AFN, Assembly of First Nations, all the chiefs that sit at the Assembly of First Nations are chiefs under the Indian Act. So it's like a, what's the word I'm thinking of? It's insidious, thank you. It's entangled. So I think to repeal it would take a significant amount of time. In my opinion, if we move towards this idea of having a new treaty relationship, then, I mean, as Naomi said, like this has been going on for years, the MK process, and it's been going on for a long time, and so nothing is going to change like tomorrow. But I know what it's like to be in the Indian Act, and I know what it's like to be out of the Indian Act. And it didn't really change who I am as a Mi'kmaq woman, but it certainly affected rights and obligations, rights that the government may have owed me through healthcare and education. So there's a fear of losing that. And when I worked in Chapel Island, I lived in Chapel Island, it is hard, it's hard to imagine how much the Indian Act affects like everything that goes on, from funding to businesses to, like I said, wills and estates. It's very, very entangled. So maybe by the time I have grandchildren and they're grown up, maybe something will change by then, but there has to be the political will of the grassroots people as well, and I respect what you've said about, you know, we have to take account of what our people want. What do we want? And that needs to be taken into account. Now I'm rambling. Go ahead.
I hope it's a faster process than that.
I hope
not
so
by the
too.
time that you have adult grandchildren. And I do think that, I mean, we need to be looking at now models for moving forward. And so, first of all, let me just say that, you know, people mean a lot of different things when they're talking about getting rid of the Indian Act. So I don't know necessarily what are the motivations. But I mean, Harper wanted to do that because he wanted to free up reserve land in order for people to sell it off. Be simple, right? So that's, I don't mean that. And also there was an attempt in 1969 for the government to, under the white paper policy, to repeal the Indian Act and repeal reserves and all special status, and under this sort of antiquated sort of idea of equality, but formal equality being like, well, we're all the same, or really assimilation writ large, because it was, Indigenous people just be like everybody else, be white and don't be Indigenous anymore. So we don't want to necessarily mean that either. I think what I want when, or what I dislike the Indian Act as much as Patti. But I mean, you don't want to just repeal it and have nothing. You have to have something. The things that are really problematic in the Indian Act is that they don't allow Indigenous people to determine who they are or make decisions for themselves. I mean, there are some limited forms of governance rights, but they're extremely limited. For up until 2014, every decision had to be essentially run past, or every bylaw had to be run past the Minister of Indigenous Affairs. And we don't have any say over who is Indigenous or who is not. We don't control citizenship. So there's many, many ways that the act is problematic. But there needs to be something legitimate to take its place, I guess, is my main point. And I think the proposal that I talked about earlier, moving towards a nation-to-nation and renegotiating treaties, but I also think we could have legislation in the next 10 or less than that, 5 years, that actually recognizes core jurisdiction in areas where nobody would debate that Indigenous people don't have the right to determine how child welfare is provided in their community or how social assistance is provided. Right now, the government makes all those decisions. And that's not even based on the Indian Act. A lot of areas, it's just the government policy without actually any legislation. That's another rant of mine.
Yes.
I'll stop.
Big one. Okay. Another question. Consent has become a strangely contested word. Are there any compelling processes that you know of that are developed by individual nations to reach consent on the terms of that nation?
Can you repeat that, please?
Yes.
Couldn't hear the question.
Yes. Are there any examples that you can talk about of Indigenous nations that have developed their own consent processes or started to do that so that they can actually reach consent when free, prior, and informed consent is valued by their government?
Okay, so I mean, there's some really interesting projects going on. There's a lot of work that's being done by some scholars now on Indigenous laws and revitalizing Indigenous laws and what that looks like. And it would, vary depending on the nation. But there's some really interesting projects that are pairing that with, for example, there's some groups in BC that are developing their own environmental protection legislation based on their values and their laws. And they're actually requiring proponents who want to go through their territory to actually go through that type of process. So there's some interesting things going on in that regard. Okay.
I'm thinking, I was thinking of BC as well, and I'm thinking also of the United States, and no, I'm not going to get Trumpicized at the moment, but the people in the Pacific Northwest, through the Bolt decision way back in the 80s, in terms of environmental assessment, the court found in Bolt way back then that the government had a responsibility to provide environmental protection to protect Aboriginal and treaty rights. And that came from the community. And I think that we're also at that point now where, and this is what I was talking about when I was saying about consent, it's like I have an opinion that because we have responsibilities as Mi'kmaq people, and I think we all have responsibilities to the territory, not to harm it, not to protect it for 7 generations. Those are our principles, and that we should be operating within that process, like our own culture and language and spirituality. That doesn't fit with a government who has a mandate for 4 years and still operates under the narrative that we are individual bands and not a nation. So, but I want to say, we can see the people who are at the truck house who are protesting against Alton Gas. To me, they are bringing the realness and the authenticity to what we need to be doing. And in terms of consent, I think that we have to be able to get out of the ban idea, get into the grassroots, respect what we say. And if we're talking about consent, we have, consent means, I don't want to say it in terms of, we have the right to say yes or no, basically. And we have to operate with that idea that we have the right to say yes or no. And we're fighting against some pretty big money, corporate structures, right? And the people that are operating at the truck house are fighting a huge fight, just like the people at Standing Rock, fighting against the Trumpers. I'm not mentioning his name again, I promise. And what I found really fascinating about the protest at Standing Rock is that there was, talking about treaties, there was a great gathering of nations, and they signed a treaty amongst themselves. And maybe part of our consent process has to be not just looking at what the government is doing to us, but also looking at what other nations are doing and start making those connections that way. So that's what I think about consent, that we need to work together. And then when we have disagreements, I totally disagree as a person, as a Mi'kmaq woman, with that Donkin mining thing. Like, are you serious? Are you kidding me?
So there's
I'm like, what? But I didn't have anything to say about it. But I should have something to say about it.
So there's a related question coming from online. Thanks for sending that. How would you propose everyone having a say in all matters that are relevant to inherent rights? How should we organize nationhood consent within our territories among ourselves first? So I think that kind of leads up to what you were just saying.
Sorry, we can't hear.
Oh, sorry. The question was, how should we organize nationhood consent within our territories among ourselves first? That sounds a lot like
What I was just saying.
yeah, you were kind of answering the question before I even asked it.
Okay.
It's great. Just wanted to recognize people online. Okay, here's a really great one. You both talked about land and ownership and responsibility in relationship to the land, and that's a common theme that comes up in conversations about reconciliation. So the way that we typically understand property is a very settler concept, is very Canadian, but how would you, or can you expand on the idea of, or like the Indigenous relationship with the land and how you were talking about it in a legal sense and a personal or a nationhood sense? Does that make sense?
Yeah.
Okay.
I was just having flashbacks to law school and property law. Green acre, red acre, black acre, purple acre, fee simple, and all these things. And that's the Canadian way. And from my understanding, Indigenous ways of, we didn't have this idea that we own the property and it was really to take care of it for the next generations. And it was a gift, and it wasn't something that we owned per se. And I think that with it's totally in contradiction to the English way of looking at land, or the British way, or the property law way of looking at land. And I think back on, this idea, like I said, that the government or the courts have called our interest in the land as Aboriginal title. It's not an ownership idea. It's just that we never thought in the old days, and I remember talking to Saugage one time, and he says, you know, we never had to own our land. We knew where our territories were, but there wasn't something written that said this is, you know, the boundary. And now we're kind of encased in a process where the only way that our property or our rights to land are recognized is through the courts and through the Indian Act. So I believe, and this is a belief, that we have rights to all our unceded territory. We never ceded it. So the way I look at that is, even under British law, they didn't even take the land in the right way. So, you know, they didn't do what they were supposed to do. And they took over our territory and left us with very little. So, but I still believe that our traditional territory is all of the maritime provinces, and that we still have an interest in that territory. And it may not exactly fit into English property law, but it is our territory. And that was, again, part of the narrative way back in the old days, where we were seen as Indigenous people as not human. And we didn't fit into the British property law system because there was this hierarchy of ownership. You know, you had to be a lord or whatever. And they seen us very much so as not able to own land and not able to, we were seen as less than human in many ways. So that's part of the narrative to me that says that we weren't allowed to have our territory because we weren't worthy enough to have it in that sense. So, does that make any sense?
Yes.
Okay. But, sorry, I was having flashbacks to law school, so I had to get over that for a second.
So I think to build on the same theme, the Truth and Reconciliation Commission report actually really delves right into this and says that our law, even our Aboriginal law, which some people think is progressive, is still extremely problematic because it's still mired in the concepts. Patti's essentially referred to them, the doctrine of terra nullius and the doctrine of discovery. And the terra nullius was this idea at the time when all these European powers were out empire building, that if they came upon empty land, it was free for the taking. And doctrine of discovery sort of developed, you know, because some people would say, well, there's actually people there. But doctrine of discovery came, you know, was informed by these views that there's a hierarchy of peoples. And there's people who are uncivilized and savage, and it's completely acceptable to be able to then assert your dominance or sovereignty on them and on their territory because you are better than they are. So the doctrine of Indigenous people were seen at the lowest level, and non-Indigenous or Europeans were seen as being at the highest level. And so actually our legal system is still pretty much still based on that, and that those bunch of cases that you referred to from the US from the 1800s takes for, and some people view it as progressive because it says when the Europeans came and they asserted their sovereignty over this land and territories, they still continue to recognize some diminished rights in the Indigenous people. And so the courts now take that as a starting point of our rights. So we have, maybe in the US they recognize more sovereignty, but a diminished sovereignty. In Canada, we didn't even go there. We just look at land rights and we think, well, they had some land rights, but it's a diminished form of land rights. And it's this sui generis kind of a way that Patti described it, but that it views that Indigenous people cannot sell their land, they have to go through the Crown, and also have to meet a fairly onerous test and actually prove Indigenous title. And so the TRC says that in order to get to real reconciliation, we need to discard that completely, move to a nation-to-nation treaty, and actually treaty would be the only basis to really justify Canadian sovereignty on these lands. We can't rely on doctrine of discovery anymore, and therefore the only legitimate basis for Canada to claim sovereignty is actually through the consent of Indigenous people through treaties. And so I think that UNDRIP is very clear in that same vein. And so I think that's where we need to go for a reconciliation. I think that gets at the land. You know, Indigenous people have land claims to land and rights to the land as much as anybody else. It doesn't fit into a Euro-Canadian view of it, but we still have legitimate claims, and they're not reduced simply by the fact that Canada asserted sovereignty over this land by sticking a flag in the ground 300 years ago. And there you go.
It's just about 8 o'clock. I think that was a great final statement.
Okay.
Unless you have any lingering thoughts you wanted to share with us. Cool. Well, thanks everyone for joining. I'll be around for a few minutes. Got some really nice posters that I'm going to be selling as a fundraiser for the Alton Gas resistance. If you want to come check them out. If you have any questions about the Council of Canadians, or you can catch our speakers on the way out the door. I'm sure they'd chat with you for a moment. Feel free to hang out for a bit and chat if you like. But thank you so much for coming.